and plays a critical part in the global economy. You may not be aware of this because of its original structure. The South African Reserve Bank Act states that it buys bills of exchange from the bank. It buys bills of exchange in the form of promissory notes, bills of exchange, and a whole host of other things. And it securitizes that with international securitization agencies. And the Reserve Bank pays the bank for these promissory notes. Now, the promissory note that they handed in to release the money for my property was signed by me. My signature gave it that value. It wasn't the bank's signature.
Right.
The bank cannot give that promissory note to the Reserve Bank and get the value for it. It can only give it to the Reserve Bank if it has my signature on it, which means that my signature makes it a valuable or a liquid instrument. So
true.
It
also means that you are the issuer of the money. You are
yes,
the actual issuer of the money.
Yes. So the Reserve Bank releases the money on my signature, which means it's my money. The bank has kept that money.
It also means that it's your obligation. That the bank is. It also means that the bank is not even a real creditor, because the bank is not providing any property for that promissory obligation. We the people are doing so.
Right. And then it goes further. In the Bills of Exchange Act, which I'll email to you so you can have a good look at that, it gives you clear outline of the definition of what is a bill of exchange. And under that definition falls, basically the outline is, it's an unconditional order in writing from one person to another, or one company to a person, or a person to a company, from one person to another, basically, for an amount of money to be paid. And that bill of exchange includes invoices, it includes a draft order, it includes a statement from a bank. If it's been signed by the people sending it, and you accept it and you endorse it with your signature, you take it under onerous title, and then you become the maker of that bill, and it becomes a liquid, valuable document, a liquid instrument, to the value what is written on it. Like $100 bill is worth $100 because that's what we accept, and it's signed on the bill by the governor of the Reserve Bank. And so it goes. So I paid off the bond with a bill of exchange as stipulated in the Bills of Exchange Act, which I accepted for value. I took it under onerous title. I made it liquid by signing it and delivering it back to Standard Bank. And it stipulates the contract is irrevocably completed when the delivery of the bill is made. So I paid it with a bill of exchange, and in the Reserve Bank Act, it stipulates that bills of exchange, promissory notes equal money. It says that they are money. So my argument is that I paid it back with money as defined in the Reserve Bank Act, whether it's bills like dollar bills or South African currency, the rand. I paid it with what is defined as money, and they have declined it. So they've declined my payment.
What's going to happen here?
They kept my money and are lying about not being paid.
Well, that's true. However, what's going to happen here is it sounds to me like you have a favorable judge, because he's considering your arguments and has even stated that he considers them intriguing. Now, and they have legal clout too. They do. But what's going to happen in the end is that the judicial system is going to find that we cannot rightly have people issuing irredeemable promises to pay as money, because it would defeat the entire purposes of our laborers, our production, and a just economy. So what we
but
need
then they're denying me of my equal rights.
They are, but but they have to resolve what the equal rights have to be. What they're going to discover is the present case of equal rights is still, while you are entitled to it on some grounds, they can't allow this to happen even on the part of the bank. They cannot continue to allow the bank to falsify its role of creditor, which in fact you are doing as well in let's say reciprocation to the banking system, which you have a right to do under the laws that but the thing is that argument can't ultimately prevail. I can only tell you this really quickly, is that I waged these arguments in 1976 here. And the banking system was so afraid of them that they would not allow them into court. Now, what I was doing differs from what you're doing. I was not claiming to pay a debt. I was challenging taxation, the government's powers or authority to tax, being as the costs of government were multiplied by this obfuscation of the currency. And so I was challenging the nature of the currency, or the obfuscation of the present currency. And in my challenge, I prescribed how to resolve all of the problems with what have proven to be, for 43 years now, irrefutable arguments. The bank's position is indefensible. But in the end, what this does is it dissolves the banking system, and it would restore your promissory obligation to its actual one rightful state, which is whatever you got for issuing the promissory obligation has paid the real creditor, which is not the banking system, has paid them in full. And therefore, your remaining obligation is to continue paying and retiring only principal from circulation, which means that in restoring your promissory obligation to its rightful state, it means two things. It means that all prior payments of interest have instead to count toward principal, and it means that an obligatory schedule of payment has to be imposed upon the obligation, which is to pay and to retire principal at no less than the rate of consumption or depreciation of the related property. So I've already created, written, authored, architected, irrefutable arguments that that's the outcome of your case. You're right to contest it on the grounds that you are, but you would be even more clever and more likely to prevail if you incorporated my arguments with your arguments and did not pretend that you have a right to resolve your debt to the bank or actual promissory obligation. Yes, you have the right to resolve the purported debt to the bank, and this is why your arguments will fly then. This will allow you to do what you owe nothing to the bank. You indeed do. Okay? But if you're going to do this, it isn't to owe nothing that you have to seek. It is to owe what you indeed owe, which is to fill an obligation to pay and to retire principal from circulation. And when you have all those arguments to provide to the court system has no reasonable action whatsoever, if they are a just court, to proceed with a trial. And this will try the banking system, and the arguments are irrefutable because the banking system never gave up lawful consideration. So the debt is not to the bank, but in the end, an obligation exists to pay and to retire principal. Now, if I can help you to understand those arguments and apply them, and you seem like a very intelligent fellow, so I don't think we're going to have any problem getting there. But the light will go on that you have a prevailing case then. So, and this would be not just a case which is important to South Africa, but it would be important to the entire world and to every bank and purported creditor or falsified creditor in the world.
Yeah, that's pretty much how I see it, Mike. So I'd appreciate it if we could pick up on this again in the next few days. The outcome of today's trial judgment was the following. The judge was not happy with the affidavit of the bank. He said
Good.
it didn't have enough. He wasn't happy with it at all, and he sent them back. He said he needs a new affidavit, a tighter affidavit, and he afforded me the same time, 15 days after they submitted their new affidavit. I then have 15 days to submit my supportive argument or argument in defense. So then we can structure the argument based on the affidavit, and I can work through it with you. I'll email you the affidavit once I have it.
I have
and then
very
we can
good news
structure
for you too, because I've got your arguments all ready to go.
Okay, awesome. And I think all I want to do is I want to take this to trial. I want to give the judge an easy way out. I think in a nice way, what actually happened today, the judge realized that, as you pointed out, his judgment could be a global precedent for banking worldwide.
We have a good judge here then.
It seems like it. And he realized that he's got to make sure that he cannot be seen to have been favorable towards either party. He has to be seen to be absolutely neutral and so forth. So in today's judgment reading, which I'm going to email to you as well as soon as I've scanned it tomorrow,
Great.
He made it clear he wants a new affidavit from them. But what he did say, he said that I presented very little argument, if no argument, in defense. And he didn't mention a single word about the bills of exchange. That was my main argument. Not a word. I find that when that happens, I see a red flag go up immediately. Mm-hmm. I see it as truth. I see it as him hiding the fact that he's thinking about the bills of exchange, but he didn't want to bring it up. And
what the problem is
let me finish this thought.
Okay.
And giving the bank possibly false hope to think that he's discarding the bills of exchange argument when in fact he's not. He just hasn't mentioned it because I didn't structure it correctly in my argument.
Right.
Now,
you haven't accounted for every aspect of all the situations. And when you do that, your judge is going to sit in his chambers and he's going to read the document that we're going to provide him. And he's going to go over it and over it and over it and find it without flaw.
Great. And that's when we want to go to trial. That's all I want. Because once we go to trial, we can bring the CEO of Standard Bank, all the different people. We can bring insiders from the banking industry. We can explain exactly how it works. Insiders from the Reserve Bank, all the top guys from the Reserve Bank, and cross-examine them and let them hang themselves. They will incriminate themselves by spilling the beans. Because if they don't.
Yes, and they will largely incriminate themselves by trying not to spill any beans, which means that they won't have any arguments. In other words, the judge will ask them what lawful consideration is, or your arguments will ask them what lawful consideration they claim to give up. And I'm likewise going to text you a link to whatdotheyknow.com, our Freedom of Information Act appeal to the Bank of England, to give you an example of their inability to invalidate our arguments.
Yeah. So I think we really are sitting on on an amazing historic moment here, because no court case in South Africa has ever gone this far. Mm-hmm. And that's exciting in itself already. So, I've got a lot of very exciting people in the community, of the Freeman community here. There are a lot of lawyers and advocates in that community themselves. None of them have been able to get this far before. So, we're going to go everywhere. But I believe we got a few important points to make. And with your help, hopefully that'll solidify it even more.
Great. I'm interested. There are permanent records, I'm sure, of this hearing, but are they in the public record?
Well, I'm going to email it to you, so we'll spread it to everybody.
Right, great. Okay, one other thing that is I'd like to offer, if you have any occasion for me to speak before your Freeman or other gatherings, feel free to rely on me. That over Skype, we can do these things and fill everyone in on